Welcome, everyone. Now we're going to officially get started. We have a good number of you here today with us. What is the topic? Something that I think is on everyone's mind. How can you protect your assets and plan in the post-election environment? There is a lot of uncertainty out there. We are here to dispel some of the myths that are out there and to help you navigate the new world that we find ourselves in as we head towards 2021 and beyond. And as we get started, we always want you to take a moment to think about why you're here. What drove you to join us here today? What are the worries that you have on your mind? What's bothering you? What's concerning you? Are you worried about your finances? Are you worried about your family's future? Are you worried about the implications of the election? Or do you just feel overwhelmed, as I think many of us do these days? We're here to help. We're here to help navigate the path forward, at least from the legal and financial side, so you can worry about the things that matter in your personal life. That's what we're here for. And as we go through this, we always want you to recenter on what the big picture is all about. Just imagine what is possible for yourself, for your children, for your grandchildren, and for your legacy. So that's what this is about. Imagine what's possible. We're going to talk about some big picture issues, and a lot of the steps we talk about, they're near-term steps you'd take, they're investments you'd make, but they can pay off literally for decades. That's what this is all about. So just take a moment for you to see Mike and I. I think it's always good to reconnect with us. So hello from the Gilfix and LaPole office. We're doing some limited in-person meetings these days, but a lot of Zoom meetings. Most people are doing a lot of that way of communicating. So it's great that we get to reach out to so many people so easily. So I know it's tough being isolated, but we're here for you and here with you. Mike, anything you want to say as we welcome people here today?
Maybe just that for those of you who had to go into the next room to look at your computer and join us, thank you for the putting up with the travel. It's funny. I mean, this whole thing, we always want to count our blessings and be positive. And, these Zoom things, I mean, we've had a number of our clients who are in Los Angeles joining us for the webinars, the Peace of Mind webinars. I see so many positives here. It's a lot easier to communicate with everybody. So again, just really glad you're here. I think you're going to really enjoy this and get a lot out of it. So it's a pleasure. It's what we like to do.
Yeah, and what we're going to talk about today, I think one of the key things, we're going to hammer this. There is a February 15th, 2021 deadline to act if you own certain types of real estate. Prop 19 is a big deal. So let's jump in. We're going to talk about that and estate taxes, but let's go to a little more detail about what our agenda is going to be. So let me go back to our slides. The agenda today, the implications of the election with a focus on Prop 19, a devastating property tax change, devastating in certain situations. And there's a deadline for acting. And we have some solutions for dealing with this if you're in the right situation. We want to talk about the 40% estate tax and what we see going forward, again, after the election. And really, this is all about protecting your home and other assets. If you have questions, submit them in the Q&A function for Zoom, and we'll try to get to as many as we can. If they're relevant as we go through these topics, we'll try to answer them as we go. And we're certainly going to take some time at the end to answer any questions you have after we've been through all this. And I know you're going to have a lot on your mind. This is high stakes stuff, and you're going to be ahead of the game once you get through this. So why don't we just set the stage? Our homes. Mike, what are your thoughts here?
Okay. So the transitions are interesting. It is important to think about the value of our homes and what the future holds. Every time we think that our homes can go up in value, they do. I mean, it's like relentless. So the house that was worth $1 million a few years ago, now it's 1 or 1.5. I mean, it's astounding. And this is just extremely important as we think about the tax issues that we're going to be talking about today. You could take one step and kind of focus on avoiding a certain kind of tax, and you might be opening the door to a bigger tax down the road, different kind of tax. So again, it's integrating tax planning in light of inexorable property value increases. So we don't want to ever take a static look at the value of our estate and say, oh, it's worth X. You have to think it's worth X, but what happens down the road? By the time I pass away, it'll be double, whatever, don't know. But again, that's comprehensive, proactive thinking, which, as you know, that's what it's all about. Okay, so you may not have a taxable estate right now. We're going to talk about the size of the estate that is taxed in just a couple of minutes. Remember, it's a 40% tax. So, and you know, this will sound funny, but it isn't just the money. It's psychologically devastating to the kids if there is a gigantic amount of money coming off the top. And in so many cases we've seen over the years, there'll be one or two properties, maybe just one. And because of the value, there's an estate tax. And because of that, they have to sell the house to have the money to pay the tax. And the whole family plan about preserving the residence for the kids or as a rental for the kids, future for the grandkids, gone. So again, Prop 19 has a dramatic impact on our thinking. We're going to go through that today, and to call it a minefield is extremely appropriate. So we're going to focus on protecting assets. That's what it's all about for you, your kids. How do all these moving parts fit together? That's our day. So let's do this. Okay. So some of you might have seen this if you sat in on the webinars that we did last week. It's kind of a hypothetical, and you know, we think it was Mark's idea, and I think it's awesome to, you know, look at a couple of real situations, the kind of things we see every day, and then we note the dramatically different outcomes, and then we try to, you know, think about it a little bit, and then come back to the solution so we can see what proactive planning can do. Okay, so we got Tom, Jill, and Amos here. Okay, so Tom, $3 million residence. We're going to say that roughly the same values for all three of these individuals. Assessed value, $300,000, right? So the property taxes are about $3,000 a year, something like that. Okay. Tom passes away in 2022. His daughters inherit the house and they're going to rent it out. Okay. Property taxes go from $3,000 up to about $30,000 a year. Okay. That's Prop 19 that we're talking now. Didn't used to be this way, did it? Okay. Jill, identical circumstances. With her, actually changed that. It says decides to rent out the house. That's a typo. Jill decides to make it her residence. Okay, that's a key difference. If Jill makes it her residence, there's some protection, but by no means complete protection. This is one of the biggest errors in the media reports about Prop 19. The Mercury, I wrote a letter to the editor and contacted a friend who's a reporter there to try to get them to straighten it out. Did the same thing with KQED, who said that if your kid inherits your house, property taxes don't go up. Wrong, absolutely wrong. In this example, property taxes go from $3,000 up to $20,000 a year, even though the daughter lives in the residence. Okay, Amos, our friend Amos, identical circumstances with one difference. He did some planning. He passes away, same time, same values. Property taxes remain at $3,000 a year. Now, before we move on, let's think about that per year. So if we're talking about a difference of like $27,000 a year plus little bits of growth, the kids will be in the house or rent out the house for 30 years, 35 years. I mean, do the math. We're talking about hundreds of thousands of dollars as a result of this change. So, okay, so what's the difference here? What's the mystery? How could we have such different outcomes?
We'll take a step back just for a moment, because this is, I think, relevant to no matter what your plan is. We recommend, and I'm sure many of you here already have this, we recommend if you have kids, and especially if you have grandkids, instead of leaving assets or properties to your kids directly, leaving them to family protection trusts. Now, why would you do this? A reminder of why Bernie Sanders wants to get rid of these. Again, that's not a political statement by me or anybody. That's what he's been on record saying. So let's just remind you, I think it's always good to get a refresher for these. If you have them, why you did them. And if you don't have them, why we recommend that you put these into place for the next generation. Lots in the media about these. The generic term is a dynasty trust. Our version is a family protection trust. Why would you do this? So again, think of this as whatever planning steps we talk about for Prop 19, for estate taxes, any situation, instead of leaving or gifting assets to your kids, at the end of the day, assets would go to family protection trusts for them. So if you have 2 kids, there'd be 2 family protection trusts. If you have 3 kids, there'd be 3 family protection trusts. Why would you do this? One, if you leave money to your child directly, they get divorced after a while. If they've commingled assets at all, a good portion could be lost. If you leave it in a family protection trust, it's like creating a prenuptial agreement for them. There's protection against divorce. It will not be lost. What you left your children plus future growth will not be lost in a divorce settlement. 2, if your child is sued, if you leave assets to them directly and they get sued, fair game in a lawsuit. If that money's in their name, there's really no protection. If it's in a family protection trust, there's protection from creditors. There's a barrier erected. It's a lot harder to get to that money that you've left for them. Someone would have to get through the trust, which is a big challenge, and can save hundreds of thousands or millions if your child is ever sued. And very importantly, we're going to talk about estate taxes, but especially if you have grandkids. If you leave assets directly to your child, that becomes his or her asset. You add that to everything that they earn during their life, that's all part of their taxable estate. So when you're looking at 20, 30, 40 years ago from now, not only will what you leave them, should the value will grow, but we don't know what estate tax laws will be in the future. You look at federal budget deficits exploding. I think it's very possible or even likely that estate taxes could be more strict when we look way long into the future than they are today. If you leave it to them directly, 30, 40, 50% of that could be lost in the way of estate taxes. If it's in a family protection trust, these assets are not part of your child's taxable estate, subject to some minor limitations. So most or all of what you leave them, plus future growth and the value of what you leave them in these trusts, goes to your grandkids with zero estate tax exposure. And you might be thinking, I don't want to create too many trusts. I don't want to tie my kids' hands. Well, you can give your kids control over these trusts at a certain age. You can give them the power to be, they can be their own trustees. So they can get these protections against divorce, lawsuits, future estate taxes, and they can still manage these trusts for themselves. So really powerful. This is a reminder, I think, for probably everyone here. If you've talked to us, we've been to our presentations before, we hammer this because we think this is an amazing solution for virtually every family. If you own property in California, especially in the Bay Area, if you have kids, and especially if you have grandkids, we think these are just critical pieces of your estate plan. So after that, that's a reminder we just want to get out of the way. Let's talk about the election. So there were two propositions we were paying close attention to, Prop 15 and Prop 19. Prop 15 lost. We're not going to spend any time on that. That would have reassessed commercial and industrial properties. Ironically, that would have really, the only corporations and large property owners would have bore the brunt of that. It wouldn't have affected that many families. Prop 19, on the other hand, affects not every, but the majority of homeowning families in California could be affected by this. And this is the one that passed, which is a bit of a surprise. I think that's more based on marketing and the messages that got out about each proposition, not really about the actual implications, but there are major implications for homeowners in California, especially if you own any rental property. Prop 19 is what we have to dig into, and that's the focus of the next section of our talk here. Mike, do you want to talk about this?
Sure. We say alert because it's a surprise. I admit it, by the way. It surprised me. I listened to the advertising. I thought I read the legislative analysis. Afterwards, Francis LaPole, our tax attorney, he really reads everything. I mean, as we should all do. I was a little guilty of not reading the text of Prop 19, but it's all there. Okay. Prop 58 is what we have. So we'll go back. Prop 13, right? That brought our property taxes way down, minuscule increases every year. Prop 58 was critical because it said that you can pass away and leave your residence to your kid or kids. Property taxes don't go up, plus another $1 million worth of assessed value, not market value, assessed value of other property. That could be 2 fourplexes, could be 3 rental properties. They were passed along without a property tax increase. So gone as of February 16th, gone. And this is big bucks. Okay.
We'll go through some examples of what this means in a second.
Yeah, for sure. So in super summary, if you pass along your residence to your kids and no child makes it his or her residence, no property tax protection whatsoever. Property taxes are completely reassessed. They could go up 1,000%, 10 times easily, right? Because your property values have gone up so much. If a child resides in the house, and this is where the incredible misinformation is, the entire property is not protected from a reassessment, only $1 million off the top. So that means that for the most part, there will be a reassessment. And we'll go through a couple more examples and some numbers in a couple of minutes. What if it's a rental property, a second home? It's not your residence. It looks like only your principal residence has this limited $1 million protection. No protection. Property taxes are going to go up. And by the way, if you think about it, if that happens, if we're going to have 10, 20, 30 extra $1,000 per year in property taxes, lots of folks are not going to be able to deal with that. They're going to be compelled to sell the house because they just can't bear these property taxes. And that does get at what, as we've thought about, one of the motivations behind the primary funding source for the proposition, which was the Realtors Association.
Yeah.
Whether you like it or not, some people think this is very fair, some don't. Whatever your view, bottom line is this is going to stimulate more sales of property because it's going to be harder to hold on to them. Again, unless we act before February 16th. So we're hyper alert to all of these issues. So, Mark, do you want me to do this one or just?
I'll go through the basics. So again, so let's go back to Tom and Jill and Amos. So again, 3 different situations. Well, starting off in the same situation, all own houses that are assessed at about $300,000 in taxable value. They're Prop 13 assessed value, $300,000. So they're all paying about $3,000 a year in property taxes. But each of these, they've owned, Tom, Jill, and Amos have all owned their homes for many, many years in the Palo Alto area. They're all worth over $3 million today. When Tom passes away, his property goes to his daughter. She doesn't live there. She's like, I'm just going to keep it as a rental property. Under the old law, whether she kept it as a rental or whether she lived there, it didn't matter. Under the old law, her property taxes would have been $3,000 a year. Under the new law, that protection is gone. Because she's not living there, there's a full reassessment of that house. Her taxes go from $3,000 a year to over $30,000 a year, significantly more than $30,000 a year, because Prop 58 is gone. We don't have that protection anymore. Jill, remember Jill's, I guess his daughter, we need to edit the slide a little bit, but again, it's another $3 million house goes to a daughter. In this case, the daughter lives in the house. So if you listen to all the marketing and frankly, even read all the articles about it or listened to NPR about it, you think, oh, well, the child's living in the house. So no reassessment, right? You still get that protection. Wrong. As Mike said, only the first $1 million in value of the house is protected from reassessment if the value's gone up from what mom or dad was paying. So she's living there, but that only means the first 1 million of this $3 million house is protected. So there still leaves $2 million in values for a reassessment, $20,000 a year or more in property taxes. So living there, it doesn't stay at her taxes don't stay at $3,000 a year. They go up from $3,000 to $20,000 or more per year. That's the protection that Prop 19 provides for kids who live in mom and dad's house. Amos, on the other hand, took steps before February 15th, 2021. And we're going to talk a little bit about it, but he took the right steps with us when he passed away. House still got the step up in basis, still got the best tax treatment. But his daughter kept his $3,000 a year property taxes. This could save hundreds of thousands of dollars or even over $1 million in her lifetime. Huge, high stakes here. So we're going to go into what this means for you and the steps you might consider taking in just a moment, but massively different outcomes. And I think number 2, Jill, that is the example that everybody's confused about. So if a child lives in mom and dad's house, wrong that they get full protection from a reassessment. As Mike said, as I'm saying here, $1 million protected, but in this area, $1 million, if you owned a house for 20, 30, 40 years, your gain is a lot bigger than that. So property taxes will go up unless you act. So Mike, we can go through the pre-February 15th, after February 15th, just to hammer this.
Yeah. We admit it. We are going to be a little bit repetitious here. We're doing it very consciously. We're going to talk about it from a couple different angles just to make sure that we get it across. So forgive us, if it seems a little redundant. And we're going to end up with kind of a decision tree that I think will help you a lot. Okay. So Prop 19, if someone passes away or transfers title appropriately before the deadline, before the new law goes into effect, property taxes don't go up. And remember, other real property, if you have a fourplex worth $2.5 million, but its assessed value is $800,000 or $500,000, you can pass that along currently, and there's no property tax increase. Afterwards, dramatic change. Maybe there'll be some protection for your residents if a child lives there, partial, but none if the child doesn't live there. Other property, completely reassessed. So again, there's our super thumbnail of what the change is and why we have to really think about it and worry about it. So let's look. This is another mini hypothetical in the next one. we've already talked about Tom, Jill, and Amos. We'll look at the property value here. So let's have an actual example. It's a profile of a client that I saw last week. Fourplex, assessed value $200,000. Okay, so property taxes are extremely low. They're actually only about 1,000 because he had a long time. Okay, market value about 2 million. Bill passes away. Property taxes go from 2,000 a year up to $20,000 a year. Worse than indefinitely, right? Because there's going to be an increase every year, and a 2% increase on 20,000 is a much bigger number than a 2% increase on 2,000. Yep. Mathematics, right? So it's compounding, so to speak. It's growing every year, the tax exposure. And in our simple example, Andre, similar situation, but he dealt with this appropriately. He took the appropriate steps. This kind of underscores the point that it isn't just a residence that you can deal with protectively. It's the investment property or the vacation home as well to protect the property taxes. Okay. So next is the decision tree. And we hate to oversimplify, but we want to give you this as kind of just a brutal summary of how to look at this, because we have to integrate, as we're going to do next, we have to integrate thinking about estate tax exposure. If you go too far down the property tax protection trail, you could be and saving money on property taxes, you could be creating more exposure to estate tax. We balance these. It's our job to think this through for you. So, when we say deadline, let me emphasize that doesn't mean you have to do it. It means that if you're going to do it after you think it through and we talk with you to analyze your situation, then you have to do it before February 16th. Okay. Not that you have to do it. It's not right for everybody, as we'll go through here in a moment. Okay. If you're a single person, unmarried, and the estate's under 5 million, all things considered, low property tax on the residence, there's a presumption that you would take steps, which would involve some pretty sophisticated moves. We're still working out some of the details, by the way, but we're nailing it down to retain the low property taxes and be sure you get a stepped up basis. And remember, stepped up basis. If you paid $200,000 for your house, that's the cost basis. If it's worth $3 million at the time of your passing, and it's in your estate, the basis goes up to $3 million, which lets your kids sell it if they want to, and there's no capital gains tax. So the stepped up basis is an important tax planning consideration. Okay, if you're single and the estate's well over 5 million, then you have to worry about the estate tax, which is a 40% tax. That may be a larger worry than the worry about property taxes. So the presumption there is a little bit different. The presumption is that you're going to focus on steps to reduce or eliminate estate tax exposure. Certainly you'll think about the property tax issue, but you're not going to go down the property tax line of thinking. You got to be a little more comprehensive, a little more sophisticated, a little more multifaceted in your thinking. Okay, so it follows. If you're a married couple, and the estate's under 10 million, then we're going to look really hard at steps you can take to avoid the property tax increases. If you're well over 10 million, then we really have to retain our primary focus on avoiding estate tax. We're not going to ignore property tax, but it is a different presumptive way of looking at things. So again, look at that for a moment, think where you are, and that'll give you just a hint of the direction that you would likely want to take as we go forward. Okay?
And we had one question, and I'm not sure that we had the answer to that, but let's say mom and dad leave a house equally to all 3 children. What if just one child lives there? Do you still get that low property tax, or do all 3 need, or just 2/3 of the house? I don't know.
I honestly don't think we have clarity on that. My assumption is that I think we would assert that you do have it because the child is making it her residence.
Yeah.
And there's a number of questions that are raised by this legislation that are not easy to answer. And time allowing, I'll go through a couple of those a little bit later on. That's a good question.
Yeah.
One of the many good questions.
Yeah, there's actually even articles. There was an article today in San Francisco Chronicle about there's a weird deadline where February 15th is the deadline for when transfers have to be made. But the upside of this is that if you're over 55, you can move 3 times within the state of California, anywhere, and keep your low property taxes. There already were some protections like that in place So it was kind of a redundant law in some ways, but apparently there's like an April date after which you can do that. So there's this weird in between time technically where no one knows how the state's going to enforce this yet. That's the bottom line. There's a lot of confusion. But we do know that February 15th is a deadline for making transfers to deal with this property tax issue. That's when this law comes into play. We don't want to mess around with missing this deadline. And you can look at our calendars, that's less than 3 months away. We got to take steps right away to, if you want to explore this, you got to start the process right away. We've developed a uniquely crafted solution. We're still honing it as we learn about the law. We have some solutions, but as Mike said, it's not just as simple as I want to keep property taxes low, I'm going to do this. You got to weigh that with other factors. And that's what we're here for. We're here to walk you through that process so you can logically decide, is this a good thing? Is it not a good thing? Does this affect my estate taxes? Does it affect, what's the trade-off that I want to make? Nothing's easy, but we actually, in many cases, it actually is a pretty clear answer, at least based on today's laws, that you got to take some action. And by action, we just mean get educated, walk through this with us. You know, we're here as a resource for you. And as we talked about before, family protection trust absolutely still a part of this. No matter what solution we pursue, having family protection trust for your kids and for the benefit of your grandkids still absolutely is a part of any steps that we would take to protect your properties from reassessments and property taxes. So the big picture, the foundational documents you've created with us and that you need to update every couple of years, they remain the same. These are steps we would take to layer on top of those. Let's take a little step back and talk about the federal election. So you might have heard some news about this over the last few weeks, but we did have a federal election as well. It wasn't just Prop 19. I know that's what we're talking about. I think that also is one reason why Prop 19 passed, was that it got lost in the shuffle. You know, there just wasn't much out there. People weren't thinking about it because we were focused on the federal election. So we have President-elect Joe Biden, and it looks like the GOP will hold on to the Senate. We don't know that yet, though, because there are going to be 2 runoffs in Georgia, and that could swing the balance of the Senate. And I have no idea what will happen. No one does. I've heard good arguments either way. But what does it mean? You know, the new election, a Democratic president, Democratic Congress or House, but likely a Republican Senate. So what we think it means is probably gridlock. We don't think much is going to change in the next 2 years when it comes to the tax code and to estate taxes. That's our focus. Our focus isn't income taxes. That's different. Estate taxes, we don't see any major changes in the next 2 years unless Georgia comes out in a way that we don't expect. If both Democrats win there, it could change. So it doesn't mean that we need to take dramatic steps from an estate tax standpoint, at least yet, unless these, again, the Georgia runoffs end up in a way that we're probably not expecting. Will tax laws change? So they could, but again, in the next couple of years, probably unlikely. Will trust law change? You know, will we still be allowed to do family protection trust? And I think absolutely yes. We see no major changes to trust law in the near term, and that means we can plan with some certainty, at least for the near future. So there's a lot of steps. Everything we talk about today, what we're here to do is advise you based on what the laws are today and what we see happening in the near term. Obviously, everything could change in the distant future. We have no idea. We're just messengers. But we think there is some good certainty for the next couple of years based on the outcome of the federal election. So I think that was something that was on a lot of people's minds. Now let's transition very specifically to the death tax, or what is actually known as the estate tax. So I think this is a good visualization of how some people feel about it, not all. And this one, I was actually looking at this, we've been debating, is this the Grim Reaper arriving and giving you a tax bill, or is a tax bill going to the Grim Reaper? Because if you notice, it's a pretty old and antiquated mailbox here. Maybe that's the Grim Reaper's mailbox, and maybe he's getting the tax bill for this family. That'd be fine with me. Let the Grim Reaper pay. Either way, we don't like the idea of estate taxes and the death tax. A lot of families don't like that, very understandably. It might mean the loss of your house in this area or other really critical assets. What are the current laws? Let's take a moment just to talk about the numbers you need to be aware of. So Mike, why don't you go
Sure. So the estate tax. Okay. You're all familiar with it. You know, you're in the fold. You're in our Peace of Mind program. And, you know, I said it earlier. I want to say again that, you know, a real benefit of being in the program is this, that there's so many webinars we do only for people who are members of the program. Some we do community-wide, but the likelihood of you being up to date and being able to respond to developments, obviously it's greater if you're kind of tied in with us. I mean, it's just an obvious point. So thank you, and pat yourselves on the back for doing it. We objectively know it's one of the best investments you ever make. So I know I didn't have to say that, but okay, going on, the estate tax. So the first thing to say is that it's a punishing tax. If your estate is exposed to the tax, it's 40%. So if the estate is 1 million over the limit, $400,000 goes to the Treasury Department. Okay. Current level of protection, very high, except for the 1 year where we had no estate tax. That happened a few years ago. It's the highest it's ever been. It's like this year, $11.58 million per person. So you double that for a couple. On January 1, our understanding, it's kind of tied into a cost of living index. On January 1, it goes up to about 11.7. So an increase, not insubstantial, not a game changer. And that's the law for a number of years. Okay. The receipt of an inheritance by your kids, not a taxable event. If there isn't estate tax, it's off the top. You add up the total value. If there's an estate tax, the estate pays it. The net after the tax is paid all goes to the next generation or to those to whom you want to leave your estate. So again, that's not taxed. Nor, by the way, is the receipt of a gift. Okay. California and estate taxes. We had one many years ago, got rid of it with a voter initiative. There is some discussion of reinstating an estate tax on the estate or an inheritance tax on those who inherit. Very different from the estate tax. Maybe the same bottom line in a way, but different. So we are in California, and there's quite a segment of the legislature in our state that is always looking for ways to increase taxes. There was some discussion in the assembly this year, didn't get out of committee, but we're watching this carefully. Personally, I think something like this is going to happen at some point, but not yet. So it's not on our radar. There's nothing to worry about in that regard. About 12 states have it, a state-to-state tax, so it's not unheard of. So we'll be watching, not now. Boy, is this a good question. What's the size of your estate? As we say now, with you, we've talked with you, we've gone through the process, so maybe you really do know the value of your estate, but generally speaking, it's more than you think. The consistent reality around here is that when we sit down with somebody and say, what is the size of your estate? And, the person thinks a little bit and they doodle and they say it's X, it's 4 million, it's 8 million, whatever. Consistently, they'll come out about 20% too low. Either they're undervaluing some assets, being conservative, or they're not counting all their assets. So just a couple of words to remind you, obviously your home, your real property is in your estate. All your investments are in your estate. Your retirement accounts, the gross value, all of that is in your estate. If you own a life insurance policy, if you pay the premiums, the death benefit is part of your taxable estate. If you have property in another state or in another country, that's part of your taxable estate. And for those of us who have individuals from whom we might inherit something, again, it's not a static analysis. You got to think about the inevitable growth in the value of your home, being a little optimistic, maybe 3, 5, 6% on investments, being cautiously optimistic, plus anything that you might inherit. So again, you got to think a little bit expansively and not be in denial. As many like me, Midwesterners, my house is worth, it's ridiculous. I still can't get my head around it. If you grew up around here, it's easier to deal with, I think. But anyway, be realistic about the size of your estate.
Yeah, we got a couple of good questions. So one, and these are kind of going back to the family protection trust issue. So one is, does one get a stepped up basis for property that goes to a family protection trust? And yes. So what matters for the stepped up basis is if it's in your taxable estate. So when mom or dad leaving assets to a family protection trust, when they pass away, there is a step up in cost basis. Now, once it's in the family protection trust down the road, when it goes from kids to grandkids, then it might not, because it's not part of their taxable estate, remember? So that's a trade-off they can make at the time. So if they want to get the step up in basis, they could take steps to take a property out of the trust. They lose those protections, but depending on taxes and their situation at the time, they would always have that option. But we're much more worried about estate taxes, because if you recall, with real estate, this gets into a different issue, but you can do 1031 exchanges. So if you have a house that's gone way up in value, you don't get a step up, you can still sell it and avoid paying property taxes if you put it into a different type of property or even different types of investments that can generate income. So when assets go to a family protection trust from mom and dad from a taxable estate, absolutely there is a step up in basis. Another question kind of related to that, for our solution for preserving property tax protections, if there are two kids involved who are trustees of a living trust, would both children need to individually have family protection trusts for our solution to work? Family protection trusts are actually independent of this solution, or the solutions we're developing. The point that we want to make is they absolutely can and should still be part of it, but whether you have them or not, our solution is independent of whether you've created family protection trusts for your kids. So we still recommend doing them. So just along Mike's notes, your estate's probably bigger than you think. Again, the value of homes, even during this kind of recession, we're seeing real estate values are still going up, especially for single family homes. But you might be thinking, well, my house is worth a lot, but it's 11.58 million per person. That's over 23 million per couple. I don't have to worry about that. Wrong. In 2026 or sooner, for those of you who are Game of Thrones fans, winter is coming. And by that, I mean the current law is going to sunset. What does sunset means? It means that if Congress and the Senate, if nothing happens to change the law before then, if Congress does nothing, which is very common for Congress, on January 1st, 2026, the exemption will be cut in half. It will go from about probably over 12 million at that point to around 6 million per person. Why is that a huge deal? Well, as Mike said, if you have a house in this area, this is 6 years from now. Let's assume houses grow at 5 or 6% per year on average. And we might have a down year, but we could have big up years. Who knows? But historically, Silicon Valley homes have gone up 7 or 8% per year. But let's take a conservative estimate. Even if your house is worth way under this limit, in 5, 6 years, it could be approaching that $6 million value, even if it's not that valuable today. So in 2026, even if nothing changes, and if you just own a house in this area, you could be getting very close to that limit. And it is very possible this law could change before then. We have the Georgia runoff, where we could have a Democrat-controlled Senate. We have 2022 elections, 2024 elections. There's 2 major rounds of elections before 2026, and maybe there'll be some sort of a budget deal. We have massive, massive deficits right now. Maybe the Republican Party will go back to being fiscally conservative, which they haven't been the last couple of years. Maybe they will take a new stance and they'll say, well, we need to control the deficit, so let's make a deal. I don't know. It's probably unlikely. But certainly 2-4 years from now, a lot could change. So we got to keep an eye on it. But that's why when Mike was talking about that decision tree, we were not talking about 11 million or $22 million as your estate value. We're talking about 5 or 6 million as the estate value cutoffs, because I think everybody here, I hope that we all hope to be alive in 2026. It's not that long from now. So we want to look ahead. And if we see other changes on the horizon, of course, we will let you know. But let's circle back to what we can do if you are fortunate enough to have a taxable estate even today, or you know that you're likely to have one in the future. What can you do independent of this property tax issue to reduce or even eliminate estate tax exposure?
So, as you know from us, there's a lot you can do. And before I go through some of these points, at the bottom of this slide, you see reference to our book. Most of you should have it. Beat Estate Tax Forever that I've written. And we actually sold out of the second edition. They're gone. And we finished the third edition. It's going to be printed within 2-3 weeks. So we will have the book. It's updated, integrates a lot of other planning ideas, and updates all the numbers that are relevant, and adds, as I said, some new thoughts. So if you have the book, the second edition, be in touch with us a little later or now to order one, the third edition, and just keep it on your radar. It'll be a really useful set of updates. Okay, so what can you do? If you're a single person and you do a living trust, that does no tax planning at all. Whether or not you have a trust, you can protect currently that 11.58 million. If you're a couple, as you know, I got to stop saying that, but you do know, you're in the Peace of Mind program. You have the alternative as a married couple, this AB trust, where it splits after the first death, or not. You can take a different approach where it stays in one, or it can divide into 3 subtrusts. So optimally structured just means what's the structure that's right for you, to address your personal objectives as well as tax planning. Okay, other things. There's a trust that we utilize for the residents that's designed not on the property tax issue, but to avoid estate tax. By the way, there's illustrations of all of these examples in the book. Family limited partnerships where there's business assets, a fourplex, eight-unit apartment building. A family limited partnership can be an entity that will enable us to discount the value of assets that you convey to the next generation, or, of course, more accurately, to the family protection trusts that you've established for the benefit of the next generation. Charitable remainder trust, if you have an asset that's gone up dramatically in value, if you sell it, huge capital gains tax. Property can go into this trust, property is sold, no tax, the amount is invested to give you maybe a 4, 5, 6% rate of return for the rest of your life. And you get some income tax breaks. Can be magical, especially if you're charitably inclined, if you have eleemosynary motivations. Life insurance, as I said earlier, if you own your life insurance policy or you pay the premiums, the death benefit is part of your taxable estate. That could be $1 million, it could be $2 million, whatever. It can make the critical difference in whether or not there's estate tax. If we instead have that policy in an irrevocable life insurance trust, the death benefit is not part of your taxable estate. Perhaps saving 40 cents on the dollar. Again, a dramatic difference. Family protection trust, remember, that doesn't avoid estate tax for you, but it's an integral part of your planning. It is going to save estate taxes, avoid estate tax when your kids pass away in the distant future for the benefit of those perfect grandchildren.
Oh, and by the way, for those of you who don't know, and I don't know why you would, I want to congratulate my dad and my mom on being grandparents for the first time. My sister Jamie had a beautiful little son, Miles Ethan Gilfix West, just about a month ago. It was October 13th, right?
Yeah.
Yeah. So we're very excited about that. I'm a
wonderful
uncle.
Thing.
I have a new little nephew, so we're very excited about that. Yeah. So as Mike says, these are just examples of the different tools that we can use. There's so many, and there's no one size fits all solution for estate tax planning, but that's where we can sometimes deliver return on investment of like 10,000% or more. I mean, we can deliver probably a better return on investment if you're engaged with us for tax planning, if you face these taxes, than any other business on earth. I mean, I can't think of any investment you can make that's more powerful when you face these issues. So the point being, keep an eye on this, and we're here to help you with this. And just to circle back, do I need to think about this if I don't have if not fortunate enough to have over a $5 million estate? Yes, you need to think about this. You want to be aware of these issues. There are annual steps you can take to reduce the taxable value of your estate. You can give $15,000 a year to as many people as you want without even reporting it. There's certain types of bills you can pay for people. There's a whole number of different steps you can take, and we can always help advise you with that. But the big picture, you need to be aware of these issues. If you just own a home in the Bay Area or any nice part of California, you need to be aware of these issues. And we're here as a resource for you. So as we get,
I'm sorry to interrupt. One thing occurred to me that I really want to stress. One of the biggest negative impacts of Prop 19 is if you are one of our many, many clients who has a child with special needs. You may have been thinking that you want to preserve your residence or a second home as the place for your special needs son or daughter to live. And the property taxes have a huge impact on that. If you don't have a lot of liquidity, and maybe you have 3 kids and you want to distribute the estate to all 3, if you leave the residence or another property to the special needs trust for your child until February 16, property taxes remain dramatically low, which means you have to put money into the special needs trust as well, but not as much. But what if the property taxes go from $2,000 to $30,000? You need another $500,000 in the trust to pay the property taxes before anything else. So it is particularly devastating in special needs families. There should have been an exception to these rules for those situations, but it doesn't exist. So your special needs situation, you just have to get together with us and talk about it.
Yeah, and I think that was so many details of this law got kind of swept under a rug, and there was a slick marketing campaign about letting you move more times and protecting fire victims. With the reality, there already kind of were some protections for fire victims. There already were protections for people who wanted to move within certain counties. So not a political statement here. We're just messengers. We're not saying it's good or bad, but there are a lot of issues that we see with this law that I think most people weren't aware of, and we still see it being misreported. So as we wrap up, what are some steps you should take to protect your family? Don't miss this opportunity. We've just gotten you guys up to speed. There is not much time to spare, but you guys are the smart money. You hear about the sharps when you're talking about sports gambling. That's the smart money. Or investments. What's the smart money doing? You are the smart money right now. You've been educated with all the tools that are available. Communicate with your family and take action. You got to explore if it's worth taking steps to protect your properties from reassessments down the road. Your peace of mind members, if you haven't used it this year, use your peace of mind meeting to review these issues for you and your family. Sooner is better. We have limited availability. We're getting booked up a lot. So I'd say if you want to explore these in detail, set a meeting as soon as you can to be with Mike or me or Nick Klingenberg in our office, Renee Conrad in our office. We're all working as a team. We don't all have availability, so we will work to try to get all of our peace of mind members in while we still have time to act. But this is a perfect use of your hour. And if you have used your hour, so what if you need to use like a billable meeting? This could be worth hundreds of thousands of dollars to go over it. Not everybody's going to take action and follow through on this. Maybe once you review it, it's not worth it to you. But I think a lot of people will. And we got to do it soon because we don't have time to do this at the last second.
Yeah, and I got to say, most of those meetings are probably going to be with Nick or Renee. It's a good thing, I guess, that Mark and I are really booked, like really booked. Renee and Nick are completely up to speed. We talk about all these, we all know these issues. So you're not going to, it'll be perfectly effective. So, with whomever you meet, same need to, as Mark said, take action.
Yeah, and Francis Lepole, our tax guru, is going to oversee all the steps we're taking. He's developing the solution. So we are all kind of working together to develop this as a team with Francis as our lead. So if you're working with, again, with Mike, with me, with Renee, with Nick, we all are working together on this. And the step 3, by the way, is ongoing planning over time. So this isn't just one step right now. We got to keep an eye on the law, and we're here for you. Your peace of mind members, we are here to serve you over time. So as we see Prop 19 evolve and how the state's going to enforce it, if you don't take action before February 15th, we're going to develop other solutions, but they're probably going to be more involved and more challenging. So we strongly recommend you take action before, but just keep an eye on estate tax issues, keep an eye on changes in law, ask us if you have questions, but we're here for you. Solutions exist. And we've hammered this multiple times. February 15th, 2021 is a key deadline. So you got to understand the trade-offs and you got to make an informed and educated decision soon. Don't wait till the last minute. If you come to us the first week or second week of February and say, okay, what do I do? We might not be able to help you. These steps take time. So we want to get you in as soon as we can. And just imagine what you can achieve with just a few planning steps now. Just imagine how much money can be saved, how you can save houses, properties for your family, and the impact that can have on the lives of your children and your grandchildren as we look to the future. It's extraordinary what we can achieve when we're educated and when we work together, and that's what we're here for. So thank you guys for being here today. We're going to answer a couple more questions. We got a few more that came in, so we're going to answer a couple of them. And Mike, as I look through a couple of these, I know you had one that you wanted to answer right away.
Actually, it was already addressed.
Okay.
Yeah, it was.
All right. So we have one question about, and this is if your kids live in a condo, can a parent pay monthly mortgage payments for their kids rather than the $15,000 annual gift to kids? Is that an effective way to do things? So that gets kind of complicated. If a parent's paying a mortgage, that gets into some detailed issues. You might just want to make the gift to your kids directly, let them pay it. Or if it's held in a family protection trust, your kids can't pay for a mortgage that's secured by a family protection trust. We'd have to kind of go through it, is the bottom line.
But let me simplify it.
Yeah.
Okay. If you're paying your kid's mortgage, it's a gift because that's a responsibility they have to pay. So if you're married and your kid is married, $15,000 for each of you, that's actually $60,000 a year that you can give your son and daughter-in-law, for example. So you can do $60,000 worth of those gifts and count that as the annual exclusion. Above that, if you're paying the mortgage, it's a gift. and technically you have to pay gift tax on that. So, you have some flexibility there. Use that annual exclusion, but it's not limitless.
Yeah, and so there are some bills you can pay directly where there's no tax, there's no problem from a tax standpoint. If you pay medical bills directly or tuition, that you can pay separately from the $15,000 annual gifts, and that is very tax efficient as long as you write the check to the institution and you don't give it to your kid and they pay the check, pay the bill. So that's a really powerful way to reduce the size of your taxable estate over time in a very simple and tax efficient way. So that would be layered in with other solutions as we talk about here. Any other questions you wanted to review? Let's get ourselves kind of back here so we can say hello to you more clearly. We've gotten some great questions here. Anything else you want to address, Mike, before we wrap up?
No. We wanted to keep this, well, we didn't really do it well under an hour, just for attention span and comfort, but we're pushing an hour now, so we should probably let it go. There will be more questions, and there's not going to be one, let me say, there's not going to be one solution. It's going to depend. And Francis Lapole, who's not just our tax attorney, he's a realtor who's very, very experienced. So he's really the perfect guy to be crafting the best solutions. And, we all have ideas and input, but Francis is truly, as our tax guru, he'll be crafting the final sets of solutions and sets of alternatives that we'll be using. So y'all come. I mean, you just got to follow up and check it out.
Yeah. And again, try to get on our calendars sooner rather than later. It's going to get a bit crazier. We had huge turnouts at our last public webinars, like bigger than we thought. So we're having a big surge. And I think as people start to realize that you can't just pass your house to your kids, and if they live there, it's fine. As that realization becomes more magnified, as people understand that, I think we're going to get an even bigger surge. So try to get your meeting set as soon as you can. Again, Mike, me, Nick, Renee, we're all available as a team to help you with this. So on that note, thank you guys so much for joining us here today. We hope you got a lot out of this. February 15th, 2021 is a key deadline. Keep an eye on that, and let's help you make an informed decision about how you move forward. So on that note, stay healthy. These are crazy times, but let's control what we can control. Let's stay healthy. Let's stay vibrant, and we're here as a resource to you. So thank you so much for joining us. Hope you have a great rest of your day.
Goodbye, all.